Constant was well aware of the dangers of subjecting the individual to the unconstrained authority of the group, and he warned against borrowing from the ancient republics the means for governments to oppress us. Constant argued that governments must protect the true modern liberty, that liberty, civil liberty, freedom from government, consisted of the individual's freedom to pursue his own interests and desires free of improper government interference. Constant argued that both kinds of liberty, ancient and modern, are critically important. A society that overemphasizes ancient liberty places too low a value upon the individual's right to freedom from the majority. A society that overemphasizes modern liberty runs the risk that citizens, enjoying their private independence and in the pursuit of their individual interests, will too easily renounce their rights to share political power. We must learn to combine the two together. In this book, while conscious of the importance of modern liberty, I seek to call increased attention to the combination's other half. I focus primarily upon the active liberty of the ancients, what Constant called the people's right to an active and constant participation in collective power. My thesis is that courts should take greater account of the Constitution's democratic nature when they interpret constitutional and statutory texts. That thesis encompasses well-known arguments for judicial modesty. The judge, compared to the legislator, lacks relevant expertise. The people must develop the political experience and they must obtain the moral education and stimulus that come from correcting their own errors. Judges, too, must display that doubt, caution, and prudence, that not being too sure of oneself, that Judge Learned Hand described as the spirit of liberty. But my thesis reaches beyond these classic arguments. It finds in the Constitution's democratic objective not simply restraint on judicial power, or an ancient counterpart of more modern protection, but also a source of judicial authority and an interpretive aid to more effective protection of ancient and modern liberty alike. It finds a basic perspective that helps make sense of our Constitution's structure, illuminating aspects that otherwise seem less coherent. Through examples, my thesis illustrates how emphasizing this democratic objective can bring us closer to achieving the proper balance to which Constant referred. The examples suggest that increased emphasis upon that objective by judges when they interpret a legal text will yield better law. Law that helps a community of individuals democratically find practical solutions to important contemporary social problems. They simultaneously illustrate the importance of a judge's considering practical consequences, that is, consequences valued in terms of constitutional purposes, when the interpretation of constitutional language is at issue. In a word, my theme is democracy and the Constitution. I illustrate a democratic theme, active liberty, which resonates throughout the Constitution. In discussing its role, I hope to illustrate how this constitutional theme can affect a judge's interpretation of a constitutional text. To illustrate a theme is not to present a general theory of constitutional interpretation. Nonetheless, themes play an important role in a judge's work. Learned Hand once compared the task of interpreting a statute to that of interpreting a musical score. No particular theory guarantees that the interpreter can fully capture the composer's intent. It makes sense to ask a musician to emphasize one theme more than another, and one can understand an interpretation that approaches a great symphony from a romantic as opposed to a classical point of view. So might a judge pay greater attention to a document's democratic theme, and so might a judge view the Constitution through a more democratic lens. The matter is primarily one of approach, perspective, and emphasis, and approach, perspective, and emphasis, even if they are not theories, play a great role in law. For one thing, emphasis matters when judges face difficult questions of statutory or constitutional interpretation. All judges use similar basic tools to help them accomplish the task. They read the text's language, along with related language in other parts of the document. They take account of its history, including history that shows what the language likely meant to those who wrote it. They look to tradition, indicating how the relevant language was and is used in the law. They examine precedents, interpreting the phrase, holding or suggesting what the phrase means and how it has been applied. They try to understand the phrase's purposes, or, in respect to many constitutional phrases, the values that it embodies. And they consider the likely consequences of the interpretive alternatives, valued in terms of the phrase's purposes. But the fact that most judges agree that these basic elements, language, history, tradition, precedent, purpose, and consequence, are useful, does not mean they agree about just where and how to use them. Some judges emphasize the use of language, history, and tradition. Others emphasize purpose and consequence. These differences of emphasis matter, and this book will explain why. For another thing, emphasis matters in respect to the specialized constitutional work of a Supreme Court justice. In my view, that work, though appellate in nature, differs from the work of a lower appellate court in an important way. Because a justice, unlike a judge on a trial or appellate court, faces a steady diet of constitutional cases, Supreme Court work leads the justice to develop a view of the Constitution as a whole. My own view is likely similar to that of others, insofar as I see the document as creating a coherent framework for a certain kind of government. Described generally, that government is democratic, it avoids concentration of too much power in too few hands, it protects personal liberty, it insists that the law respect each individual equally, and it acts only upon the basis of law itself. The document embodies these general objectives in discrete provisions. In respect to democratic government, for example, the Constitution insists that Congress meet at least once each year, that elections take place every 2 or 4 or 6 years, that representation be based upon a census that must take place every decade, and it has gradually extended the right to vote to all adult men and women of every race and religion. It also guarantees the states a republican form of government. But my view can differ from the views of various others in the way in which I understand the relation between the Constitution's democratic objective and its other general objectives. My view can differ in the comparative significance I attach to each general objective. And my view can differ in the way I understand how a particular objective should influence the interpretation of a broader provision, and not just those provisions that refer to it directly. These differences, too, are often a matter of degree, a matter of perspective or emphasis, rather than a radical disagreement about the general nature of the Constitution or its basic objectives. Finally, the fact that members of historically different Supreme Courts have emphasized different constitutional themes, objectives, or approaches over time allows us to characterize a court during a period of its history and to speak meaningfully about changes in the court's judicial philosophy over time. Thus, one can characterize the early 19th century as a period during which the court, through its interpretations of the Constitution, helped to establish the authority of the federal government, including the federal judiciary. One can characterize the late 19th and early 20th centuries as a period during which the court overly emphasized the Constitution's protection of private property, as, for example, in Lochner versus New York, where, over the dissent of Justice Oliver Wendell Holmes, it held that state maximum hour laws violated freedom of contract. At the same time, that court wrongly underemphasized The basic objectives